Thanks very much. I guess I should open by thanking all of you for staying. I will explain by telling you that we were having weather in New York. I was on the 10 o'clock shuttle, which at least mercifully wasn't canceled. It took off at 12:20. So thank you for staying here. My assigned topic today is 9/11 and war crimes, which I guess could be subtitled A Study in Equivalence. And I think that analyzing why 9/11 was a war crime is probably less interesting and useful than discussing what to do about such war crimes, which I think probably better suits what should be the purposes of a group of, from my perspective, young people, since it's principally the people in your age cohort who are going to have to live with the results or live under the results if we get it wrong. But I think it's nonetheless important to consider the Geneva Conventions and their purpose so that nobody makes decisions on anything but a principled way and a clear-headed way. I think actually that the topic of 9/11 and war crimes subsumes kind of a two-part question. It asks first whether we can effectively thwart terrorist designs on the United States by employing simply judicial methods. And just to anticipate the correct answer to that one, if not, what would I propose? Before I get to the lawyer's part of this, just two quick points. The first is that neither what are called present judicial methods, which presumably means civilian courts with an occasional use of a military commission, nor any alternative that I might propose can be the principal instrument to thwart terrorist designs on the United States. I remember back in the 1990s when I was serving as a district judge in Manhattan, walking with one of my colleagues, the late John Sprizzo, on Pearl Street during one of the terrorism trials that was being held at the time. He looked at the concrete barriers and the marshals wearing flak jackets and carrying long guns, and he said in his characteristically understated way, what the hell are we doing here? This isn't a legal problem, this is a military problem. Robert Gates, the former Secretary of Defense, has said famously that we can't kill our way out of this. And there may be differing views on that, but I'll tell you for sure that we can't convict our way out of it either, whether in civilian courts or military courts or any other courts. So where these issues get heard isn't going to resolve our conflict with Islamist fanatics. The second point I want to make is that the only definitive answer to the question, as I've kind of redefined it, that can be given in a democracy is an answer that comes from the political branches, which is to say Congress and the President, and has the support, or at least the grudging acquiescence, of a majority of the country. It has to be an answer that does not simply define the forum in which prosecutions take place, but also antecedent questions of who we wish to incapacitate or punish and for what. It's emphatically not an answer that should be provided by the judicial branch, and yet that seems to be where most of the action has been. Turning back now to the questions that I mentioned, the temptation is simply to say no to the first question, whether the judicial approach is the correct one, and then launch into a detailed description of a system that might do better than the system that's currently being used, assuming that one would describe what's currently being used as a system, which in itself would make an interesting discussion. But I don't think that would be fair either to you or to the topic, because I think we have to examine why the answer is no to judicial methods in general to deal with a terrorist threat to this country. So the first subsidiary question to question one is, what is it we have in place today? The answer is not at all clear. As of today, what's in place is that the 5 people who were charged with planning the September 11 attack on this country are now being held at Guantanamo. They, along with Abdul Rahim al-Nashiri, who's charged with planning the attack on the USS Cole in 2000, along with a couple of his co-defendants, who are also held at Guantanamo, are going to be tried by a military tribunal. This is actually the way it was proceeding in November of 2009, with the lead conspirator in the 9/11 case, Khalid Sheikh Mohammed, announcing his intention to plead guilty and go right to the sentencing phase so that he could achieve martyrdom. And when the current Attorney General suddenly aborted the process and announced that Khalid Sheikh Mohammed, or KSM as he's known, and the other 4 would be brought to the United States and tried in a civilian court. Congress reacted by passing a law that bars the use of any funds to transfer anyone from Guantanamo for trial in the mainland United States, and the administration has in turn reacted to that by refusing to bring any additional prisoners to Guantanamo, so it's kind of a standoff. In April 2011, the the United States captured a former leader of al-Shabaab, which is the al-Qaeda franchise in Somalia, who was then helping another al-Qaeda franchise, al-Qaeda in the Arabian Peninsula, or AQAP, which is based in Yemen. Because the administration would not bring any new prisoners to Guantanamo, that prisoner, Ahmed Abdul Qadir Warsame, was held for 2 months aboard a ship and then transferred to the United States, where he will be tried before a civilian jury in New York, although his alleged crimes occurred either in Somalia or in Yemen. So how did we get here? Well, I guess we should start with the laws of war, mainly the Geneva Conventions, which is a system of rules designed to keep war within certain bounds. It's a system to which countries voluntarily adhere. That is, they take on the obligation to have their soldiers fight in uniform and carry their weapons openly, follow a recognized chain of command so that they can tell their soldiers and so that they can be subject to discipline and higher-ups held accountable if the soldiers do not follow the rules, and also to give up certain tactics, including targeting civilians and using certain weapons, including poison gas and dum-dum bullets. In return, the soldiers who obey the rules are entitled to be humanely treated if they're captured, not to be required to disclose information beyond the now familiar name, rank, and serial number. As to those who fight as guerrillas or other irregulars out of uniform, not carrying weapons openly, not following a recognized chain of command, possibly targeting civilians, they are not entitled to the protections of the Geneva Conventions and, in fact, can be charged with war crimes, put on trial before military tribunals or commissions, and executed if found guilty. Military commissions have been used by the United States even before the Geneva Conventions. President Washington used them to try rebels during the Whiskey Rebellion. After the assassination of Abraham Lincoln, the participants in the plot, other than John Wilkes Booth, who of course died of wounds while he was being pursued, those participants were tried before a military commission, even though the Civil War by then was already over. German saboteurs who landed on the coasts of Florida and Long Island in 1942 were captured and tried before a military commission in Washington on explicit orders of President Roosevelt, who did not want them tried in a civilian court. They were tried, convicted, had their rather rudimentary appeals heard, including by the Supreme Court, and except for 2 who were spared, were executed as unlawful combatants, all within 3 months, a process that was explicitly upheld by the Supreme Court in an opinion that was issued after they were already dead, even though one of the men claimed to be an American citizen. One interesting detail of that case shows how important it has been historically to conform to the laws of war in order to receive the protection of those laws. During the actual landing in 1942, which is the most vulnerable part of an operation like that, and the time when those who participate in it are in the greatest danger of being caught, the saboteurs wore uniforms. They changed their clothes and buried their uniforms on the beach before going inland. The only conceivable explanation for that is that they knew that if they were captured in uniform during the landing, they would have at least a credible claim or a colorable claim to be treated as prisoners of war rather than as unlawful combatants. I think they were willing even to raise the risk of detection somewhat by stopping to change their clothes rather than risk summary treatment and eventual execution by landing out of uniform. The advantages of military over civilian tribunals from the government standpoint include rules that allow evidence to be received based on a fairly simple and straightforward standard. That is the evidence relevant and does it appear to be reliable? So, for example, if a soldier captures someone who's not in uniform and is planning an IED, it might be acceptable to receive evidence in the form of an affidavit from that soldier as to the capture, rather than requiring him to appear at a hearing. Also, if the soldier questions that defendant and gets admissions and other statements, those statements can be used before a military commission if evidence of them appears to be reliable, even if no Miranda warnings are given. The military commission system gives the defendant a military lawyer who has received security clearance, and there are procedures for handling classified information that allow such information to be used without compromising national security. The facility constructed at Guantanamo includes a multi-million-dollar secure electronic system for handling classified information that can be transmitted from anywhere in the world and maintained securely. The civilian system, which is designed for routine criminal cases, includes rules, some constitutionally based, that do not permit out-of-court statements like affidavits to be offered as evidence and require strict adherence to other rules that you would expect would characterize a system that is skewed in favor of defendants. It's a system that's based on the assumption that it's better to let 10 guilty defendants go free than for one innocent to be convicted, because values that we refer to with the shorthand phrase due process, including the right to a lawyer at all stages, the right to confront witnesses, the right to a speedy trial, and the like, are of overriding importance and cannot yield to expediency in any case and in any way. The assumption underlying military commissions and the procedure used in such commissions sets a much higher value on national security. In order to deal with the problem through any means other than civilian courts, we have to face up to the simple truth that national security is in fact at risk when we confront Islamist terrorists. We seem to cross that bridge after September 11, 2001, but we seem to have recrossed it in the opposite direction since. So at the risk of restating what others may describe in more detail and a lot better, we are dealing with a phenomenon that is a threat to national security because it's intended, at least in part, to show that our government cannot perform the most basic task of a government, which is to protect people and keep them alive and to protect property. Once you say that, what's the argument for using civilian courts at all in these cases? Now, I'm at somewhat of a disadvantage here because I'm not a proponent of using the civilian courts, but those who are make several arguments. First, they argue that we have used them in the past and they have been successful. Well, that's half right. We have used them in the past and there have been convictions. But in absolute numbers, those convictions have been few and they've come at an enormous cost and burden to the civilian court system, including the substantial cost of maintaining security for all participants, including jurors, witnesses, prosecutors, and judges, and with hidden costs as well. For example, the rules applied in terrorism cases are the same as the rules applied in routine criminal cases, whether involving stock fraud or drug dealing or any other of the crimes that are routinely prosecuted in our courts. If rulings are made that tend to relax search and seizure standards, for example, or standards requiring early access to counsel, because a judge is trying to avoid suppressing evidence that's highly relevant and could convict a terrorist, that relaxed standard is going to be applied in routine cases as well, with the result that rulings that start out in terrorism cases can influence the standards applied in other cases to the detriment of criminal defendants generally. Also, because rules of evidence and procedure in civilian cases are weighted in favor of defendants, there's a lot greater risk that classified information or information that should otherwise be kept confidential is released, either because the defendant has the right to conduct discovery to some of the government's evidence before trial, or because sensitive facts can come out in the normal course of a trial, either as part of cross-examination or otherwise. For example, a defense lawyer in a criminal case may want to probe into how his or her client's name came to be on a list of those to be arrested. If the witness is an agent of the CIA or otherwise involved in gathering intelligence, do we really want to require that the government disclose its means and methods of gathering intelligence in a public courtroom? If defense lawyers are aware that such disclosures are a cause for concern, they will, and quite properly, try to probe for sensitive information, if only to make the government object and create the impression that information is being hidden from the jury. Another example, it's routine when an indictment includes a conspiracy charge, and they almost always do, to require the government to tell the defendant who all the known conspirators are, even those who are not named in the indictment. That was done in one of the cases that I tried, the Abdul Rahman case that was referred to earlier. He and his co-defendants were tried back in 1995. That list of unindicted co-conspirators included a then relatively obscure person named Osama bin Laden. Within weeks after that list was turned over to the defense, and this was learned a couple of years later, it had made its way to bin Laden in Khartoum, where he was then living, and it told him not only that his identity was known, but also told him who else's identity was known by the government. He left Khartoum shortly after that, and the list itself was found in his vacated headquarters years later. There have been other problems as well. Zacarias Moussaoui, the so-called 20th hijacker who was supposed to be part of the 9/11 attack but was prevented from doing so because he was arrested on an immigration violation several weeks before, pleaded guilty. His sentencing proceeding alone took over a year. His case took 4 years to wend its way through the courts, and it's not done yet. And there isn't much comfort even in the affirmance of his conviction by the Fourth Circuit Court of Appeals. That opinion, affirming his conviction, suggested that if Moussaoui had not pleaded guilty and had gone to trial, he may well have been entitled to access to a great deal of classified information and to call other detainees as witnesses and turn the trial, as he did the sentencing proceeding, into a circus. What other arguments do proponents of civilian courts make? Well, they argue that we uphold the rule of law, or uphold it more robustly, if we try accused terrorists in civilian courts than if we try them before military tribunals or in some other forum. The short answer to that is a simple denial. No, it does not uphold the rule of law to tell people who refuse to obey the laws of war that they're going to get better treatment by violating those laws than by obeying them. Another variation on that argument is that if we try unlawful combatants in some other court, either a military tribunal or some established terror court, then we will establish two standards of justice, one involving traditional and constitutional protections and one not. Well, yes, but recall that we're talking about unlawful combatants. We're talking about people who have dealt themselves out of the traditional protections of even the laws of war, let alone the laws of our courts. Certainly, if the standards of procedure and proof are more relaxed in a tribunal other than a civilian court, that increases the chances of a mistake. But recall also that the only people who will stand trial at all in such a tribunal are people who are not only unlawful combatants, but also charged with war crimes. There's no excuse for encouraging mistakes, even in the designation of an unlawful combatant, and there should be a continuing review procedure to make sure that we're not, in fact, holding innocent people, as there is. But recall that the alternative is to say, essentially, that if you obey the laws of war, you carry arms openly, you wear a uniform, you follow a recognized chain of command, and you don't target civilians, then you would be entitled to the protections of the laws of war, including the Geneva Conventions, and you can be detained for the duration of the conflict. But if you violate those rules, you commit murder, even mass murder of civilians, or try to do so, then we've got an even better deal for you. We'll give you a lawyer, all the traditional protections of a conventional legal proceeding in a civilian court, and in the course of doing that, we will necessarily provide you also with a public forum in which you can have the assistance of a lawyer in putting the government on trial as well, and spreading whatever in the way of propaganda in support of what you stand for, and in opposition to what the United States stands for, as you wish. Although I'm not among those who think that it's, although I'm among those who do think that it's not an acceptable alternative, however difficult it may be, to hold people indefinitely or to maintain two forums, one for the prosecution of crimes committed in pursuit of conventional criminal goals and the other for prosecution of crimes committed in pursuit of apocalyptic goals. It is, I think, easier to do that than to reward terrorists, I should say, with better treatment than we give to those who obey the laws of war. Our military commission is the long-term answer for dealing with captured terrorists. As I said before, I think the definitive answer to that should be given by the political branches. But as of now, military commissions appear the only alternative to courts, certainly the only alternative game in town. But are military commissions the most desirable alternative forum? As they are presently constituted, I don't think so. In fact, discussions of whether civilian courts or military tribunals are the better choice remind me of a debate about which of two chimps is the better violin player. The short answer is that neither is very good. First of all, the job of the military is to fight wars, not to run an alternative justice system. The way people advance in the military is by doing that. Yes, the military has a Judge Advocate General's branch, but that's only an adjunct to its warfighting mission. It is not a separate mission in itself. I think it's fair to say that there's a certain lack of enthusiasm in the military for becoming full-time jailers and executioners, particularly in connection with a program that is not popular in the civilian world. Although it is true that we've used military commissions before, we've never used them on a long-term basis. And I think the lack of enthusiasm that I mentioned may eventually express itself in lack of performance, as it has on a couple of occasions already. I have only intuition to rely on, but I think it's pretty sound. If we're to have a system in place long-term, I think it has to be one that at least has access to the kind of talent and commitment that the civilian justice system has available in its prosecutors and in its defense lawyers. If military commissions are to continue, I think that at the lawyer level, they have to have access to such people. Beyond that, I can't give you the blueprint for an alternative forum. All I can do is say that it has to be one that protects classified information, doesn't simply provide a propaganda stage for those who try to justify a religion-based impulse to kill us, and yet permits us to distinguish those who've committed war crimes from those who have not, or as to whom there is substantial doubt about whether they have or not. That's the wish list. Any system that does that should suffice. But unless such a system is functioning in a society that recognizes that we are dealing here with a militant, religion-based ideology, and that these are not people who want to commit violence for the hell of it, that the violence is simply a means to an end, unless there is clarity of thought, we're not going to prevail, no matter how many trials we hold, and for that matter, no matter how many terrorists we kill, whether with drones or otherwise. But I'd like to end on an up note. And the up note is that I think the majority of citizens are coming to understand what it is we're dealing with, and we're coming to understand that the ism of the 21st century, Islamism, is to be understood just as we eventually came to understand the isms of the 20th century, fascism and communism, before we prevailed over them. Perhaps the most celebrated judge in U.S. history, Learned Hand, said in a speech in 1944 that the spirit of liberty is the spirit that is not too sure that it is right. Well, whether or not he was correct when he said that, or whether he was simply indulging a luxury that he had because the outcome of World War II was by 1944 pretty obvious. Whichever it is, when we deal with people who are sure enough that they are right to fly airplanes into buildings, we had better respond with enough confidence that we are right, not only to keep the spirit of liberty, but also to keep ourselves and our children alive. I thank you very much for the pleasure of speaking to you, and I'd be happy to take questions.
Who wants to go first?
Yes, sir.
I guess just trying to understand your proposed system better. Do you make any distinction between suspected terrorists who are citizens and those who are not American citizens?
No. Nor did I should say that was part of my point about the case that I mentioned involving the German saboteurs. One of them claimed that he was a citizen, Haupt. The Supreme Court's response was that that was immaterial, that once he had attached himself to a foreign force, he forfeited any rights of citizenship. That is not, under law, the standard now, but if you're asking for my preference, that's it. Yes?
How do we distinguish between the two branches of crime clear enough to prevent undermining the traditional safeguards? Particularly an example like a drive-by shooting or arson. It's not so clear to me under the category.
Drive-by shootings and arsons are conventional crimes.
What distinguishes a drive-by shooting from an act of terror?
The point of doing it.
But that's totally subjective.
No, it's not subjective. It can be proved by objective evidence. If, as in fact happened at Fort Hood, Texas, somebody gets up and shouts Allahu Akbar and mows down 13 people, I think you can take that pretty much at face value, particularly when it turns out that he's been in touch with Anwar al-Awlaki, who we, as you know, killed in a drone strike, who was a principal al-Qaeda organizer based in Yemen. Those are two very different things, notwithstanding that I should tell you that the Army's after-action report on that incident referred nowhere to Islamism and described the event as workplace violence, which is kind of what people engage in when they don't like the food or the soda machine doesn't work properly. So the point of this talk was we've got to get our heads around this before we can deal successfully with it. Yes?
It seems like both the justice system and the military system, they don't want to deal with this. They want to pass it off.
Correct.
What would the come in there? Because I have a feeling that they don't think the justice system should have it because the hard work that they put into trying to capture these people, they feel could go down the drain, and the hard work, just how they got them, might make them look like the demigods of the world.
The short of it is I don't know, but it's not, I think, up to the civilian justice system and the military justice system to sort of play hot potato with, right, here, you take it. I should tell you that when the Justice Department decided that it was going to be the one to decide, this was right after the 2008 election and the new administration took over, they decided that the Justice Department would determine who was released from Guantanamo and who wasn't. The Defense Department couldn't get the files to the Justice Department fast enough. They must have broken every land speed record in existence. Nobody wants the job. But in a democracy, the people who do the job don't get to decide whether they do it. The political branches, Congress, the President, get to decide who does the job and why, and explain why. Yeah.
Sorry.
I'm sorry, yes.
So your Ford Hood example, why is there resistance by some to label that an act of terrorism?
Well, the Army Chief of Staff at the time, who was a good, I mean, obviously he didn't get to be Army Chief of Staff without being an enormously skillful general. But he went on television after that happened and said that the greatest tragedy would be if the Army's diversity program suffered as a result. Now, I'm sorry. The greatest tragedy is not that the Army's diversity program suffers as a result. Is that you got 13 people dead, dozens more injured, and their lives ruined, and the lives of their families ruined, and a country terrorized. That's worse. There is a level of political correctness that is gradually, I think, wearing away. But that's the only thing I can think of that explains why it is that after-action report didn't do anything to really analyze why this happened, and why this guy, for example, was passed over, not passed over, but was passed through and promoted repeatedly, in spite of blinking red lights indicating that he was a major risk. Yes?
If there's an alternative system put into place, how would you distinguish the rules of evidence as we have them now to those tribunals? Because as the soldiers are interrogating these folks, they're not necessarily following the exact rules that we follow in the United States.
Hopefully not, although at one point there was a suggestion that captures in Afghanistan should be followed with Miranda warnings. I think the touchstone should be reliability of the evidence and relevance of the evidence. And the question of weight should be for the fact finder. It is possible to get a reliable confession without a Miranda warning. It's possible to get an unreliable one, too. But that, it seems to me, is up to a fact finder to decide. Obviously, I also think that you need to be able to close a courtroom when necessary in order to receive classified information. It's very hard to do that in a civilian system. The facility at Guantanamo, which I've seen, is designed at the cost of hundreds of millions of dollars of your tax dollars and mine, it's got a place for the press. It's got terrific electronic equipment that they can use to shut off access to the well of the court when necessary, as well as transmit documents in real time from any location in the world. So it's a perfect facility. It's also remote, secure, and humane. Trouble is to get people to face up to that. Yes?
President Obama just passed a new immigration policy, and I'm just wondering what your thoughts are on it, and also how you think it'll affect the election year.
That's a little beyond my subject. How it's going to affect, I mean, that's for pundits, and I'm really not a pundit. Bottom line, as a matter of policy, I agree with it. As a matter of procedure, though, I don't think that the president, and in fact, he, at an earlier time, said it was not for the president, by executive order, to determine how this problem gets resolved. That we have laws, and it was for Congress to pass and enforce, and the executive to enforce them. It's a problem. Yes.
Have you commented at all publicly about the Fast and Furious program?
No.
Okay. Even though you've been pulled into it to some extent.
That's why.
Yeah.
Yeah. I mean, there will be an Inspector General's report at some point, and I believe that will tell a lot more of the story than's been told up until now. Yes.
Moving kind of back to the 9/11 and war crimes, what are our obligations under the anti-torture treaty signed by Reagan and ratified 6 years later?
Our obligations are defined in domestic law. We don't torture, and the torture statute is very specific. It defines torture. It's not a figure of speech. Torture is inflicting under color of law severe physical or mental pain or suffering. Not just pain or suffering, severe physical, mental, or mental pain or suffering, and severe mental suffering is defined in mental pain or suffering is defined in durational terms. There's got to be something lasting. What was done under the ridiculously named enhanced interrogation program under the administration in which I served was not torture, including waterboarding, which was done to 3 people. And I'll be happy to discuss it with you and tell you what it involves and tell you. Regrettably, the Attorney General chose to release the classified OLC memos that describe this technique. It involved putting somebody on a tilted piece of wood, tilted bench, strapping him down, covering his face with a cloth, and pouring water over his nose and mouth for some period ranging between 20 and 40 seconds when he was trying to breathe. Stop, do it again, stop, under very strictly defined rules with a physician present after he'd been given a special diet so that he didn't throw up. And it was used on 3 people. That's what the fuss is about. Khalid Sheikh Mohammed, Abdul Rahim al-Nashiri, the guy I mentioned who was the mastermind of the Cole bombing, and a man named Abu Zubaydah, who was a senior ranking member of al-Qaeda. We got rivers of intelligence from those people. Up until 2006, fully 50% of the leads that we had came from those interrogations. Now, did they break because of waterboarding? I have no idea, because the way it's done is not simply to have, to waterboard somebody and then ask them questions and write down the answers and go out and act on them. If somebody, the way any good homicide detective would question a prisoner, if you're getting lies from people, then you know they're not being cooperative, and then you bring in somebody else who will get them in a mood to be cooperative, and then you bring back the original interrogator. And the information that is gotten from those people isn't just acted on. It is combined with other information that the government has so as to determine whether it's accurate or not. There was another element at work here, which was something that was actually made known to us by Abu Zubaydah, who was the first guy who was waterboarded. And that is that these folks believed that they had an obligation to resist to the limit of their ability. It was a religious obligation, but that once that was reached, then they could talk. And in fact, after Abu Zubaydah broke, he said, "You should do this for all the brothers." That was his statement. Nonetheless, it required very strict supervision and permission from either the deputy director of the CIA or the director of the CIA to use the interrogation methods that were at the top of, that were the most coercive. And of course, the people who got it kind of self-selected. I mean, they were the people who resisted everything else, and they were the people as to whom we had every reason to anticipate that they had valuable knowledge. In the case of Khalid Sheikh Mohammed, once he broke, he used to give chalk talks describing the organization of al-Qaeda, the funding of al-Qaeda, gave up numerous people and cells, and prevented a lot of death and destruction. I mean, there are people walking around today who would not be walking around but for the fact that those methods were used. So our obligation is to obey the torture statute. I should tell you that there are 2 other statutes in force that were not in force at the time. The Military Commission, standards under the Military Commissions Act and the Detainee Treatment Act, both of which speak in very general terms. I think one of them calls it, you can't use degrading or some other, I mean, there are various adjectives. Nobody actually, Congress had an opportunity to outlaw waterboarding twice. They defeated it both times. But they speak in general terms. Now, whether those statutes outlaw that technique or not, I don't know. They may. Nobody's had occasion to pass on it because we haven't used those techniques since 2003. It's a long answer to a short question. Yes?
What grade would you give the current Justice Department in terms of everything?
I don't, look, I'm not, I don't, no, I'm not going to do grades. I'll talk about policies. But, and I also don't like to get in, I mean, this isn't, as another character named Michael said in another connection, this isn't personal, it's business. So I'd prefer to stick to business and talk about policies rather than giving people grades. Yes?
I just have it's more of a general criminal procedure question. Do you think that cities, counties, and towns should have sovereign immunity against unreasonable search and seizure that is done by police officers, or do you think that they should be held accountable for the actions of police officers?
They are held accountable. They don't have, under governing federal law, certainly, they don't have sovereign immunity. They can be sued in federal court for violations of civil rights and are. And yeah, I think they have to be held accountable. That's not to say that I favor, turning it into a cornucopia for the plaintiff's bar. And the standards have to be pretty high. But certainly acting under color of law to deprive somebody of civil rights is barred under federal law, and people can be prosecuted criminally for that. Yes?
Well, on the same subject, you know about the U.S. v. Jones case, like, a few months ago, search and seizure? Yeah.
Yes, right, that putting a GPS device on is a search.
What are your thoughts on reintroducing the trespass doctrine to search and seizure?
Trespass doctrine is part of search and seizure. You can't enter private property without a warrant or good cause.
I mean, that as opposed to a reasonable expectation of privacy.
I prefer reasonable expectation of privacy because you can leave private property in all kinds of places where you have no reasonable expectation of privacy in it, and you can be in all kinds of places where you have no reasonable expectation of privacy. But it's something I would need to think through about where the difference, where it would take you. But I don't see a problem with a reasonable expectation of privacy standard, so long as we keep reasonable in place. Yes.
When you are the Attorney General, how do you balance what cases you want that you all take on with politics, with what actually is pressing? There is a balance, obviously, and depending on the administration, you would argue that there's more politics than less. But how do you go about deciding that?
You can't prosecute everything all the time with the same level of intensity. So you establish priorities, and an Attorney General is, in that respect, part of an administration. The administration sets the priorities, and then you go out and follow them. That's not to say that you don't prosecute crimes when evidence comes to hand. When I was there, the priorities that I walked into really were the southwest border, gangs, terrorism, of course, and civil rights, which was because of the upcoming election, the Civil Rights Division had to be kind of geared up to protect the election and to make sure that it functioned properly. Those were the 4 priorities. You can't have, if you have 12 priorities, you've got no priorities at all. So you really do need to establish priorities in law enforcement. And administrations do that. People run for president on platforms that involve stressing certain kinds of prosecutions. And then people who serve further down the chain are expected to follow those priorities in a general way as to how they allocate their resources and so on. Obviously, if your priorities are the ones that I described, and you have a bank robbery in town, you prosecute that. That's how it gets done, and every administration has done it that way. Attorneys general, I think, don't generally get involved in, or shouldn't, specific cases, except in reviewing capital cases where the government requests the death penalty. That is required for every single case. But other than that, there's a very carefully calibrated chain of command that has to be followed and should be followed, and the only time people get in trouble is when they don't. Yes?
Do you think the new voter ID laws
No. I mean, look at the things you have to show your ID for. I mean, you have to buy beer and do all kinds of other stuff. And as far as people not having IDs, I think the government provides them, as I understand it, gratis, and even provides transportation to go get them gratis.
All right, thank you very much.
I mean, again, I'm sorry I was late, but there's nothing I can do about that.